this thing matter tomorrow.
Motion.
Yes.
What is your subject matter?
My lord.
What is your subject matter?
Subject matter, my lord. They are interfaith couple, my lord.
Hmm?
Interfaith couple. Facing life threat.
Monday. Team number 4. 4 unit 5. 4. You are for petitioner. Okay, you know authorized.
There is no private respondent, lord.
CGC,
Okay.
revenue, government, railway. You should have informed. Government advocate is there. CGC. Okay. Sir. Net counsel for the petitioners has sought adjournment of the cases for 2 weeks. Mr. S.S. Roy, learned Central Government Council. Mr. Aforesaid, learned Standing Council Revenue Department. And Mr. J. Hendrick, learned Junior Government Advocate for the official respondents who are present have submitted that they have no objection to the prayer for adjournment. Those of us sought for these the cases after 2 weeks on a date to be fixed by the office.
Deeply obliged, sir.
May I please, Your Lordship, with regard to item number 10, supplementary, as per yesterday's Lordship has asked for, we need some more time to get the documents, Lordship. Kindly 10 weeks, 10 days.
What document?
Lordship, some documents was asked for.
No, we have decided we will dispose of. Only we have granted time. Outside. Otherwise, you are disposing of. Fixing the case today. All parties yesterday. Tell Mr. Chalke for present.
Lordship. All right.
The daily list for admission. I don't know one.
Slip as Dr. Saaf is not in station, Lordship.
Not in station.
Out of station, Lordship.
Okay.
My lords, I appear on behalf of respondents 2 and 3.
2 and 3. 2 and 3 is CCI.
CCI, my lord.
Okay.
My only request is that a short date may be given. I'm not opposing the adjournment.
Miss
D.
Mr. A. Kaushik, learned counsel for the petitioner, has submitted that Dr. A. Saraf, learned senior counsel who is leading him in this case, is out of station due to personal reason. And in that connection, my mention memo has also been circulated yesterday, seeking adjournment. Full stop. Miss
D. Gupta, my lords.
D. Gupta, learned counsel for the respondent number 2 and 3, and Mr. B. Chaudhary, learned counsel for the respondent number 4 are present. Full stop. In view of circulation of the mention memo yesterday. Okay, the prayer for adjournment is allowed. And for considering the ground cited, the prayer for adjournment is allowed. List, but it will be after 15th August. List the case, cite the full matter, fix.
25th August. 2508.
A sort for an executive and council board of parties, list the case on so and so.
Yes, my lords. 25th may
25th, I'm
be.
out of station, my lord. 18th, my lord.
18 to giving me this
20.
after
18 of course.
7.
27.
27.
Deeply obliged.
Deeply obliged, my lords.
Deeply obliged.
Item 2.
Is necessary. After submission of the appointments, the petitioners submitted a representation before the respondent number 7 on 1/11/2025, seeking release of the additional amount of rupees 8,33,780 estimated for the structures towards Ziraat Complex. Structures standing on the subject property towards Ziraat Complex. Post op. Having received no response to the said representation, the petitioners have approached this court by the instant present writ petition, seeking inter alia a direction to release the reassessed amount of rupees 25,01,206, including the additional amount of rupees 18 lakhs assessed by the respondent. Just like standing over the subject property once we are complete over any vote. The original estimate eight structures at rupees 6 lakh. $67,000. So this is your case. Page 23. Perfect. Page 20. Okay. Now, have you gone there to receive?
They had gone there. In fact, there is an order of his honorable court. Thereafter also they have gone. They will not release with the amount. But you will find that order on 9/3/2026. While issuing notice. 9/3/2026. His honorable court's order.
While compensation amount has been received, Ziraat amount though assessed has not been paid. This is a submission.
Was in the Athol case.
No, on 9/3, it is court recorded that it is contended that while the compensation amount has been received, the Ziraat amount though assessed has not been paid. That I don't know. It is recorded.
The doctor that has not been released yet.
No, everything you are entitled. 13 lakh you are entitled. No, there is no doubt.
That has not been. Yeah, that amount also not.
Post. Para. The contention of the petitioners that they are entitled to receive the additional, the amount of rupees 25 lakh, 1,206 has been traversed by the respondent number 7 in his affidavit in opposition. It has been extenuated in the affidavit in opposition of the respondent number 7, who was the competent authority in opposition, Kala, for the project. The award under section 3Z within bracket 1 of the NH Act was declared by him on 14/7/2023, based on valuation of affected structures made by the Public Works Department within bracket building. Of trees by the Department of Forest within bracket horticulture and the Department of Agriculture of the Government of Assam. Also, it is stated that a joint site verification was done with the stakeholders and a field report was prepared for declaring compensation under section 3G. A public was published on 6/7/2023 in 2 newspapers. Award says for award under section 3G was thereafter approved by the respondent, by the requiring authority, that is the NHIDCL. In terms of, and thereafter, the compensation amounts awarded under section 3G 1 by the Kala had been deposited with him as per section 3H1 of the NH on 11/2023 for disbursement. The section 3H in bracket 2 to the beneficiaries. Where the subsection as per of the NH Act, comma, publication with declaration under subsection 1 of section 3D, comma, the length, the process of mentioned in the declaration based absolutely in the central government, free from all income taxes under section 3D2. When land is acquired under the NH Act, comma, the total is equal to easy one for the acquired. PH within bracket 1. Or opposite of that amount, section TZ by the central government with a competent authority land acquisition before taking possession of the acquired land. Full stop. Section 3H within bracket 2 has prescribed that as soon as maybe after the amount has been deposited under subsection 1, which shall on behalf of the central government pay the amount to the person or persons entitled thereto. Full stop. Is after the the equity authority derives the right to take connection of section 3E is of relevance. Full stop. As per subsection 1 of section 3E, comma, where any land has vested in the central government under section 3D within bracket 2, comma, and the amount determined by the competent authority land acquisition (CALA) under section 3Z with respect to such land has been deposited under section 3H within bracket 1. Central government a person who may be in possession of such land to surrender or deliver possession thereof to the CALA or any person duly authorized by it in that behalf within 60 days of service of the notice. From the materials, from the statements and requirements, from the materials on record, comma, 8. The notice dated 29/9/2023 was issued only after the completion of the procedure laid down in section 3D within bracket 2, comma, section 3Z within bracket 1, and section 3H within bracket 1 of the NH Act. Where the initiation from the end of the petitioner for additional compensation was made only after, only on 8/11/2023 onwards, that is, after the notice dated 29/9/2023 issued under Section 3E1 or from the respond number 7 as the Kala, seek the compensation amount assessed and finally the acquiring authority to take over possession of the in the exercise undertaken subsequent to the representations of the petitioner, the respondent number 9, after the re-verification, has found that the for the structures standing under subject property, the petitioners would be entitled to receive a total amount of rupees 25 lakhs per annum, which comprise of two components, rupees 6 lakhs as the original estimated value and rupees 18 lakh 33,078. Six lakhs 37,000. Yes, with the Section 3G limited one. Again, bit further. Two estimated. Find just one name for the structures. Building on the subject. The applicants have contended that they are not satisfied. So, well, I have contended that. So, subsequent estimates prepared by the assessed towards zero standing something. The petitioner has further should ask and say for the you live any mount awarded towards the land. It has been concluded on behalf of the respondent number 7 that the deputy commissioner, the jurisdictional deputy commissioner, sorry, the respondent number 6, that is the deputy commissioner Kamrup, had no jurisdiction for reassessment and refixation of the valuation under the National Highway. And similarly, the circle officers, Soregaon Revenue Circle, also had no jurisdiction of his own for reassessment and refixation of the valuation under the National Highways Act. So yet, the state two authorities had received the from the petitioners and proceeded for verification and reassessment of the valuation of the structures belonging on the subject standing on the subject property to the authorities in the Public Works Department. That is the respondent number 9. It is further contained. As respondent number 7, that as he as the competent authority land acquisition for the project had not issued any direction for reassessment and re-verification of the structures standing on the subject property. The subsequent revised valuation, subsequent reassessment or revised estimate prepared by the respondent number 9 and the instruction of the respondent 6 and circle officer. Circle officer is beyond the scope of statutory process contained in the NH Act 1956. Process of re-verification. Reassessment or revised estimate subsequent to the award passed by on 14/7/2011 by its force from the provisions of such re-verification, reassessment, revised estimates, etc. for the structure standing on the subject property. 6. First sample of the circle. To the Authorities upon Works Department. Building. So, It's it cannot be made relatable. We need. Response number 6, nor the jurisdictional circle officer. Still it. The, since it is the petitioners have stated that they have not received, they have neither received the compensation assessed towards the plot of land, nor the commission assessed towards Jirat till date. No, nothing. It is the petitioners. It is contended on behalf of the petitioners that the amount assessed towards the plot of land as well as the compensation assessed as Zirat and the Zirat compensation assessed for the structures standing on the subject property are not not adequate, and the amounts to assess require enhancement. Such a contention, such contention regarding enhanced compensation and that is not to be repeated in read petition. Depend on the 6 of the Constitution. Not acceptable to them, not acceptable to them. Is there and above, comma. In addition to this following words, release the reassess area compensation amount of spending by lakh one. Application is still pertains to inadequacy and non-acceptability of the compensation amount assessed at rupees 13 lakh. 852. Where is that page? 13 lakh, 24,000. 852. Still pertains to inadequacy amount determined by the competent authority land acquisition Kala at rupees 13,34,852. Such issues can be raised by the petitioners as a beneficiary only before, and the same can be examined. Can be raised before. The same can be examined on considered by an advocate appointed under section 3G within bracket 5 of the NH Act 1956. In such backdrop, it's true. Supporting documents in support of their claim for enhancement of the compensation amount before the arbitrator at the earliest. It is accordingly observed. So, any such application is preferred by the petitioners before the arbitrator so appointed. Can dispose of the application as expeditiously as possible. Post of para the official respondents who are in custody and possession of the relevant records of land acquisition in respect of the subject property belonging to the petitioners and for the and the reference shall transmit the relevant records to the office of the arbitrator so as to facilitate the arbitrator to dispose of the application by taking into consideration the factors delineated in subsection 7 of section 3G and following the procedure mentioned in subsection 6 of section 3G of the NH Act in an expeditious manner. Post of para. It is submitted at the bar that by an order dated 6/3/2025, the Revenue and Disaster Management Department, Government of Assam, Pursuant to notification number SO 4606 within bracket E dated 22/10/2024 of the Ministry of Road Transport and Highways, Government of India, has appointed. She is still there? Miss Meenakshi Das Nath, SCS, Secretary to the Government of Assam, Revenue and Disaster Management Department to function as the arbitrator appointed under subsection 5 of section 3G of the NH Act with immediate effect and until further orders. And the said order dated 6/3/2025 is still in currency. Post up. Madam, the petitioners are therefore. Somebody placed it before the court. Yesterday I asked
Yes,
Ms. Bodole to get the.
yes. But then somebody has just told me that we are.
Please check it. We don't know because they will be helter going here and there. Let us be in the order. Otherwise, you submit it, circle officer will. Everybody moves around everybody. Let us be specific. Then again they will come. Because petitions are filed that no.
I'll get it
Today now. I asked Ms. Bodule yesterday.
She has given me that, but I somehow.
Okay. Get it clarified. Petitions on the court. For a compensation amount, the same be filed before the arbitrator. Promotional arbitrator. As 13th. No, if you can still make an application. With that has to be with protest again.
That will be.
Registering a protest. Otherwise, you admit there are many things. If you do not register a protest, under protest, the petitioners are also at liberty to receive the amount of rupees 13 lakhs so and so, which had already been assessed by the compensatory Kala under section 3G1 under protest. Under protest, as the petitioners petitioners have canvassed that they are in need of the said amount.
Even the petitioner approaches the responding authorities, they will release the amount within a fixed period of time.
If such an application is filed by the petitioners, the competent authority and acquisition shall release the petitioner, shall release the said amount at the earliest, as the notice in that connection, as the notice under section 3E had already been issued by him as far back as on 29/9/2023. The position also there.
Yeah, position already taken by.
Already taken.
Already taken.
Good. With the above, with the observation made and the direction given above, the writ petition is disposed of. Mr. Das, you be there. Let me examine what are the second case. Just a minute. I'll come back. Mr. Das, you need not be here. Let. 13 to Nironi or 13. Okay, DNAT is standing out PWD. Or Mr. B. Chaudhary. That B. Chaudhary likhiba or DNAT likhiba. Second to DNAT, B. Chaudhary likhiba, standing out PWD. 8 and 9. Subject property of hero. Number 748. Stated that he has been residing on a plot of land. Number 748, comma, situated village Borhanti Moniari, Moja Soyani, Polavari Revenue Circle, District Kamrup Metro, by it is stated that the family of the petitioner has been residing on the said plot of land since the time of its forefathers, and by constructing an Assam type house along with big boundary walls, etc. And after required to a subject property also. 3 notice call 29/9/2023 type 13/10/2023. Zirat completion amount 13,40,821. Where is the notice? The notice is the page 20.
Sorry, Lordship, 22.
A representation
Presentation 23, dated 1/11/23.
1 or 2?
1/11/23, Lordship. Page
One
23.
representation.
One representation.
Okay,
Lordship.
1. That is to other 1. 1/11/2023.
Lordship, the other order is the same. Here it is
Hmm.
STP 77.
A respondent number 9 or on refixation value আছিল ন 22/12/2023 আছে তাতে কম্পোনেন্টটো কৰিব তাতে ফিগাৰটো মই ইয়েলো কৰি দিছো STP আগৰটো 91 আছিল ন এটোত STP 77. So initial is 13,50,000. 319.
319.
Total is 26 lakh.
46,756.
Baki 26/8/2025 is same.
Representation date is also same, 1/11/25.
Hmm?
The last representation date is same.
Last representation date is same. যিটো আছিল আপোনাৰ 1/11/2011 same. What? When? No, award was 21/8/2023. Award 3G1 award. Newspaper publication. মই দুইটাতে হালধীয়া কৰি দিছো, যদি ডেটটো চেঞ্জ থাকে চেঞ্জ কৰি দিব। Newspaper publication different date.
10/8/23.
মই হালধীয়া কৰি দিছো হা।
Deposited.
আছিল ইয়াতে নহয়, মানুহজন নিজে, মানুহ কোনো মৰা নাই আৰু গভৰ্ণমেণ্ট ডাক নাম্বাৰ। আৰ্বিট্ৰেটৰ সেই দুটাতে সাবমিটেড এটা বাৰ আছিল ন, 6/5/2026 আৰু লেডিগৰাকীৰ নাম আছিল ন। এতিয়া বিদ্যুৎ বিকাশ ভাগৱতী ACS secretary to the government, sorry, gazette notification number SO, মই আগৰখন দি দিছো আৰু লেটেষ্টখন দি হালধীয়া মাৰি দিছো, আপুনি গম পাই যাব। He's working. He's still.
Item 14.
Where is Mr. M. Sharma?
Lordship, he is in another matter.
What is your instruction?
Lordship, the instruction is that
Making
we have
out
two
the-
cyber complaints from, one is from Maharashtra, Lordship, and another is from Odisha.
Anything written?
No, Lordship.
Have you made out something?
Lordship, we have to file the affidavit if we have to provide.
That is why Mr. Sharma is asked. If he submits, then we can
Lordship, we have
dispose of.
already received the instruction. There is no requirement of affidavit.
Whatever his verbal instruction, we also do.
The disputed amount is around 33, Lordship.
Not around, it has to be specific.
Yes.
Is there any mention in the body of the repetition?
No, Lordship.
Yesterday he was saying 49 rupees something something.
No, 33, Lordship.
Ask Mr. Sharma to be present. Here's the instruction.
Yes. Okay, let's.
Timing method, item number 3.
Senior counsel is some personal difficulty. Kindly adjourn for the day.
Who is your senior counsel?
AM Khan. AM Khan.
What is the matter? Yes, are you filing any affidavits
I pray for.
or not required?
I will file.
7, 8 days.
Manoj,
What? Where is an impugn order?
Annexure 4. Page 30. Page 32.
Legal point only. Whether recounting can be ordered
Yes.
by an interim order or only by a final order. But he has said that all the ballot papers of the election be produced before this court and the seal trunk to facilitate this court for recounting of votes on or before the next order date. Cannot be. No affidavit is required. Yes, where is Mr. Khan? That is why the court has granted stay. Constitution has said recounting can be ordered because the sanctity of the election process cannot be interfered with by an interim order. Recounting of votes can be only after a region order passed at the end of an election petition, final order. It cannot be by an interim order. Privacy is subject to Mr. Khan's submission. Oh, Khan has said it is you. It is now burden is on you. Burden is on you. Khan has come.
My lord, in the petition.
Khan has
my lord.
come against the interim order,
Yes.
making his submission clear that surprisingly the Panchayat Election Tribunal has passed the impugn order based on the allegation of the election petitioner. Now you respond number 6. You respond
Yes, my lord. There are
on the point of law. First, maybe the difference is 1 vote or 2 vote,
2 votes. Yes.
whatever. Can such an order be passed by an election tribunal as an interim order? If this kind of interim order is allowed,
The order was passed only after hearing. both the
no,
parties.
not here. Hearing will not do. What is his reason? No reason.
Page 32, my lord.
Based upon evidence laid
Yes,
by
yes.
the parties. Where is the evidence?
That was not ideal.
Then, is it sustainable? Opsora Begum. More judgment. It is Supreme Court judgment. Yes, Mr. Roy. Yes, Deputy Commissioner can be directed to preserve the ballots.
Ballots, not for recount.
But he says to facilitate this court for recounting of
Recounting.
votes on or before the next day.
Next. That's why. Lord.
Support. Support this interim order.
When to dispose of the.
No, you write down
Yes, ma'am.
1975. Code SSA 822. Supreme Court. Supreme Court. It says, this court has repeatedly said that an order for inspection and recount of ballot papers cannot be made as a matter of course. The reason is twofold. 1 and 2. Then, the court would be justified in ordering a recount of the ballot papers only where three conditions. Second condition is that on the basis of evidence adduced, such allegations are prima facie established,
Yes.
affording a good ground for believing that there has been a mistake in counting. Evidence led. Have you laid evidence?
No.
Have you
Before reducing evidence.
entered the witness box?
No.
Then thereafter, 1993, Supply 2, SCC 82. Same principle. And there are numerous others. That is why a court at the first instance granted absolute stay. Go through it, come back. Whether you have made out any case. Precision of the matter. Need gross irregularities
Yes.
committed during sorting of ballots by blah blah blah, any authority,
Ghana Tribunal
X,
found
Y, Z authorities.
anomalies in the counting. Yes.
Right. That will be at the end, that will be final order. The recounting of votes will be final order.
Yes.
Suppose an MLA or MP or Panchayat member is elected, say to the highest authority, by such kind of order, petition is allowed, then sanctity of the election process will be gone to the drain. WPC 1001. Individual decisions.
In next week, Michael.
No. Right now. Madam. Opportunity.
Yes, madam.
And you were there. Date of the motion itself.
Yes, madam.
I have given you the decision.
Yes.
Evidence must be laid
Yes.
before ordering for recount. And he has said that I will recount before the next date. Is it not? But that can be only after a judgment. After allowing both the parties to lead evidence. Now there is here only petition has been filed making allegations regarding commission of irregularities. He cannot directly recount. As simple as that. We'll take up. Yes.
Supplementary list, items 7 and 8.
As Dr. Saraf is out of station, Lordship, today, the submissions of the petitioner in item number 7 may be recorded today and our submissions may be referred. till the next date of hearing as fixed by your lordship.
I cannot retain so much submissions on
Lordship,
the same issue. Yes, Mr. Kanodia. Difficult.
What-
I have heard you at some length,
But due respect, serial 8, what I saw from the impugned order, my issue and that issue is maybe relating to education cess, but totally on there they have got the refund. Here I am seeking a refund.
okay.
What I read from the order, I don't have the.
I don't know. I have not opened.
Lordship.
I have opened only your file on the previous day.
That is on my side. It is a case only to be decided whether a pending list was there or not. When the judgment.
In your case, these two cesses are not refunded to you,
Lordship.
and you are claiming
Because of
refund.
Unicorn. My claim was with them. It was pending. They returned my claim on the ground of some other litigation. That other litigation they pursued till division bench of our High Court. They lost it. Now while refunding that amount, they refer to Unicorn. So whether a pending list.
No, whether these, Mr. Now, you two are there. Now I'll ask Mr. Kayal whether the issues in the two petition are similar or different.
It is similar lots.
Similar.
Yeah, lots.
Lordship had indicated last day that because Lordship had heard me, I can complete my submissions today. And then whenever convenient, Mr. Dr. Singh.
No, Mr. Kanodia, it is very difficult for me to
Then Lordship, as per your Lordships.
retain. I don't have
What-
that much of
What are your
RAM,
Lordships?
RAM.
Whatever your Lordships decides, any next day.
When Mr. Dr. Saraf will be available?
Lordship on the next week. Next week, Lordship, I have
No, I have lined up other cases also.
13th
yes.
August if convenient to your Lordship.
Discounts now. No, I have to see because I have lined up few cases.
13th August is a Thursday, Lordship. I will be here for some. If your Lordship convenient, if it is convenient to Dr. Saraf.
13 now.
Thursday.
Person available on 20th August 20.
Just
Find out. Mr. Kal, are you sure? Both the issues
Yes,
are
yes, lordship. 100% lots.
100%.
No.
Okay, then I have no way out.
20th. Oh.
20th. Okay. Mr. A. Kanodia.
But the compilation which I prepared, shall I hand over to your Lordships or on the next day?
You can give it if I have the time.
Check your, because
I'll keep it in the record.
Lordship.
1 minute. Mr. A. Kanodia, learned counsel for the petition. I'll not keep as parted, but it will come back to me again.
It is already parted by your Lords.
No, but there are some notifications also.
Yes, sir.
There are some notifications also.
Lord.
So as a precautionary measure, I will not do it. But you make the submission. If somehow it is listed before another bench, you make a submission that it is substantially heard by another bench.
Lordship.
Right. In case, because the other one, Mr. Kaushik's petition will be taken up by Justice Borua.
It cannot be taken
It
up.
cannot.
So in that case, if I am sitting in bench 5, it will come back to me only.
Lots.
Right?
Yes.
Or Mr. Kyle, you be the common factor in both the petition. You make the submission that substantially
Lots.
hard. Because otherwise, keeping this part out
Lordship.
is difficult unless we segregate both the matters. And it may happen that if I decide Kanodia's case, it may have an effect
Bearing on the
item number 8.
No, Lordship. In that case, Lordship, when Mr. Cal is submitting, it is similar. Then fine.
Okay, Mr. A. Kanodia and counsel for the petition, and Mr. S. C. Kyle, senior counsel, and senior special counsel, CGST, for the respondents in both the Kanodia in 7. for the petition in 7. The senior counsel and special counsel CGST for the respondents in both the writ petitions are present. First of Mr. A. Kosik, learned counsel appearing for the petitioner in I-8 has submitted that Ms. Dr. A. Sarah, learned senior counsel who is leading him in this case, is out of station due to personal reason and has sought for listing of the case on another date. First of, in view of the ground cited, the learned counsel appearing for the other parties have consented to the prayer for adjournment made by Mr. Kosik. First of, as sought for and agreed to by the learned counsel for the parties, list the cases on 20/08/2026. First of, the cases are not to be treated as parted.
Okay, lots, much,
But it is open for Mr. Kyle to make the submission
lots,
that are substance.
lots.
There's an interim order.
The interim orders, whoever passed earlier shall continue.
Not in my case.
Whoever passed
But
earlier
get.
shall continue till the
Only
next
of
date.
that. Get to it, much of that.
Item 10,
That's not it.
Yesterday, what?
Lordship, I want some time, Lordship, because your Lordship has asked that regarding the whether that notification is there or not, Lordship. But as per telephonic instruction, Lordship, I
No,
got
the
Lordship,
notification about 808.
808, Lordship.
It is admittedly not there.
Not there, Lordship, but the reason is, Lordship, in the year 1962, Lordship, that land was handed over to the central government. That is why, Lordship, I have to obtain that
Huh?
record, Lordship.
1962?
62, Lordship. As per tele- Yes, Lordship.
That time NHIDCL was not there.
Lordship, as per telephonic instruction, Lordship, that land was earlier handed over to the central government by the state PWD, Lordship. And since that land is central government, Lordship, as per that information, that is why in the notification it was
But
not.
circle officer says it is government land.
Lordship, government land, what
And
government?
it is
State
not
government
under
or se-
3D, not
Lordship,
under 3D,
Lordship,
808.
yes. That is why, Lordship, that land was not included, Lordship. Since that land is already in the name of central government, that is why in the 3A and 3D it was not included. That is my telephonic instruction. So I have to obtain that written instruction.
I'll forget them.
7 days or 10 days, Lordship.
We have invested time, all of us,
Lordship,
is it not?
Lordship.
Cycle officers or district administrations affidavit.
One is page
Page
98.
1 minute, circle officer.
Latest affidavit, Lordship, will find page 104 onwards.
Circle officer says eviction was actually carried out on the adjoining dark number 808, meaning the right, not in 808, which is recorded as roadside land in record. Do you have any copy of Chita or something? Revenue records, 808.
Lordship, I have annexed in my affidavit, Lordship.
Okay, just a minute,
Lordship, will
just a
find
minute.
in page 121.
So circle officer says it is roadside land.
That Sita copy is 121 page.
Then let us see first NHIDC. A08, which is as per record available with the revenue authority is roadside land.
And
According NHIDC, according to.
Yes, Lordship.
Then
Copy, Lordship.
120.
One of my affidavit.
Which affidavit do you have?
Filed by NHIDCL, Lordship. It was filed on Lordship. 8526.
85/2026.
Filed by Lordship one officer, Lordship Binayak Kumar. Case 121.
By respondent number?
Respondent number, my lord, respondent number 1, 6, 7, and 8.
On 85.
Yes.
104. Neil, class is Neil. And Sorkari. By some notification or something.
No, Lordship, that notification was.
OM.
Yes.
OM.
OM ৰ মাধ্যমে উল্লেখ কৰা অনুসৰি উক্ত দাগৰ ভূমি শ্ৰেণী নাই শ্ৰেণীলৈ নামাঙ্কন কৰা হ'ল।
আৰু ৰেকৰ্ডত ব্যৱহাৰ শ্ৰেণী নাই হিচাপে গণ্য কৰা হ'ব।
So 9 is 9. No. At top, that is why.
Yes, sir.
Where is aside? রাস্তার কাছ। ভূমিলক্ষ্য, that man on the building that thing, who is recording it? সরকারি অভিভাবক নয়। See, if it is national highway land, highway administrator has power. Yes. If it is government land, state government has power. Then state. That is the issue. That's the only issue. But after exchange of pleading, after hearing all of you, now you are saying instruction. Now you are saying somebody else
Lordship,
already informed.
page 118 is one sketch map, Lordship, which shows, Lordship, that some portion of land is in extreme right of way. That is, land is falling under the extreme right of way equation.
It doesn't disclose anything. It is Sorkari land.
Yes, here also, Lordship.
Some National Highway Act also. national highway, all lands appertaining to the highway. The highway. Or transferred for such purpose by the state government to the central government. So it has to be transferred
That's,
or acquired.
I would like to add on that point, Lordship. Lordship, state, land is a state subject under 80.
That
Rule
is
1880.
already clear.
So-
As per the entry.
Yes, 18 of the state list. If the central government want to take possession of the land, it has to be acquired under the law. The law is the.
Or to be
highway.
transferred.
Yes, it has to be transferred. So if it is transferred, it would have been earmarked in the map as a for that purpose. If it is national highway, it is earmarked as a national highway. My learned friend is now trying to develop.
Now let just a minute notification. Let us have the notification. Some notification was there, 3D. Wait. 71. The start page. First page, first page.
650, Lordship, 60.
60. So it is widening or four laning. So earlier it was narrow, two lane maybe,
Now
it was widen. Now the question is if the widening is there and this whole process of land acquisition has been initiated from two lane to four lane. After four lane, it was near to 808 was near to four lane.
4 lane.
Not near to two lane.
2 lane.
Now you are saying a story about 1962.
Lordship, that is over telephone, Lordship, that is not written, Lordship, but Lordship, that is why, Lordship, for written instruction, Lordship, I prayed, Lordship.
Therefore, you say that it is not disposing of the reputation, keeping it pending with a stay order. Stay order has been passed. Interest of petition. Yeah, no. Yes, good. On. Is the owning of 777 and 789 under Patna number 102. And the contents of the notice. Review notice dated 21/12/2024. Annex 9. That he had made unauthorized occupation of National Highway 17. Good stuff. The issue is by the respondents is about unauthorized construction by the petitioner in the area of land under that number A08. On the relief part. By the it's in deference to the order dated 21/5/2026. An affidavit has been filed by the respondent number 4 on 16/6/2026, enclosing a report dated prepared on 6/6/2026. After carrying out the joint verification contrary to the direction made by the court to carry out an exercise to measure the actual area of land presently under possession of petitioner. The report has purportedly mentioned about only mention only about the actual area under unauthorized possession of the petitioner, measuring 67.25 square meter within bracket 7 to 3.87 square feet, page 143, comma equivalent approximately equivalent to approximately 5.0. The report is silent about the actual area and the position of the petitioner. With both for finding out about the authorized position and unauthorized position of the petition. Today, Mr. HCIL has made a submission that the areas of land covered by that number 808 has been was limited over
That is,
the central
Lordship,
government.
over
As per the act in the year 1962. And he has sought for a week's time to substantiate such contention. Contrary to which is State is contrary to state government by the respondent number 4 that which appears to be contrary to the condition government made by the respondent number 4 that flag number 808 is recorded as roadside land in that page 98. Land. Doctor, Mr. Retrieve the document of 1962. Mr. Taluja will come again and say, so not on a hearing date. We will not release this case on a
Lordship, that
hearing date.
1960
First he will ascertain, then we will
Lordship,
fix.
that year,
The interim order passed, I shall
Lordship.
continue. Interim order was there.
Lordship, may I pray that year, that 1960, that should not be reflected. That is over. That is central government, Lordship. It is true, Lordship. They have informed me, Lordship.
You have made submission.
Lordship, but Lordship, that is should not be
Maybe
reflected, then
82, 92.
Lordship.
Let us come back.
Lordship.
Otherwise, you will not come back.
Lordship.
10th August, 10th July.
Also.
Lordship, Lordship.
Item number 11.
So the speaking order. Because he has made an observation only circle officer.
Yes.
So the deputy commissioner has not passed any order. He has to either issue the NOC or to
Reject.
is the service you have asked for. Mr. Das. You have applied for what?
To place, my lord, page 36.
Oh, that is the judgment.
Yes, my lord. Judgment, my lord, in their affidavit in opposition, they have annexed, my lord. For judgment, my lord, page, my lord, starts from 34.
No. Application you have submitted for what? Where is your application?
Yes, my lord.
Central.
It was, my lord, annexed up to, my lord,
Sure.
Yes. annexed up to.
Composite land shall transfer.
Yes.
Yes.
When is it?
24 by the circle officer. Instead of rejecting the said application, you should give a chance to the petitioner that you collect it and correct it. State may reject it, again I apply for this.
Okay.
It's
Revenue received not submitted.
yes, madam.
We have submitted.
Submitted. Page 20, my lord, annexure 4. What shows there, my lord, is, at 126, he applied for application was submitted and received. Because application was forwarded to LRA, LRA was forwarded its report to site officer. And all the title storage does.
Junior Government Book in Assam.
3 and 4.
For the respond number 3 and 4. Full stop. Four. Last page. On. 9/8/2025, second application.
Yes, madam.
That's for the. Come on. Five plus. 1, 6. Look, 1, 2, 2. 1, 1. Third sale deed dated 17/9/1998. For the purpose of the sale stroke purchase transaction, investor shall obtain sale permission from the office of the subdivisional officer, Abhayapuri on 14/9/1998. After registration of the sale deed, the seller, Bireshwar Sil handed over the possession of the subject plot to the petitioner with proper demarcation of boundaries. And since then, the petitioner has been in continuous occupation of the subject plot. Full stop. The subject plot stood mutated in favor of the petitioner by a mutation order dated 15/10/1998, passed in mutation case number 6/1997. Subject plot after 6/10/19 software. Pursuant to a letter of the Commissioner and Secretary to the Government of Assam, Revenue Department, addressed to the settlement officer Goalpara, Roman and Bongaigaon, District Goalpara, wide dated 16/7 on the subject matter, quote, correction of land records, unquote. Containing a direction to correct the land records of number of parcels of land to pass status, those parcels of land, including the subject, the status of those parcels of land, including the subject plot, was sales to government cast land when conversion of the status of the subject plot to government cast land came to the knowledge of the petitioner in the revenue records, came to the knowledge in respect of the subject plot, came to the knowledge of the petitioner, the petitioner preferred a review petition number review petition number 179/2019, in a writ petition WPC number 2393/2025. where a judgment was rendered on 29/3/2017. Full stop. By an order dated 22/01/2020, passed in review petition number 179/2019, the writ petition, WBC number 2393/2015 was restored to file. Full stop. After restoration of the writ petition, WBC number 2393/2015 to file, the same was disposed of by an order dated 19/2/2020. Number of directions. Full stop. After disposal of writ petition by order dated 19/2/2020, the Circle Officer Srijangram Revenue Circle of Vayapuri, state is, Miss case number 56/2022, within the Alima Shoria versus Bireswar Sil, for the purpose of considering the case of the petitioner. For to examine whether the subject of is to be converted to the examine regarding the status of the subject plot. The proceedings of this case number 56/2023 was not been brought to its logical conclusion common the petitioners. Which was a writ petition. WBC number 6717/2023. This court, after considering the facts and circumstances in its entirety and a judgment in order dated 9/2/2022 rendered in 4594/2020. Dispose of the petition. WPC number 6717/2023. Holding that the case of the petitioner is similarly situated to the case of the two petitioners in WPC number 4594/2020. Consequently, further direction has been made to the Deputy Commissioner Omega for consideration of mutation of the petitioner's name in respect of the subject of on the basis of the sale deed executed on 17/9/1998. Close the quote. Right. Pursuant to the judgment. Passing the institution WBC number 6717/2023. The name of the petitioner was vacated. Aspect of a subject of by an order dated 30 by an order dated 33/2024. And in support of such fact, the petitioner has annexed a copy of the Jamabandi pertaining to the subject of as annexed to the restoration of the petitioner's land in the revenue record by such mutation. Or with a mutation. Petitioner yes, she was in need of fund, comma, any agreement for sale of land? Okay, is it purpose intended to sell the subject plot to an intending purchaser, comma, visit does. Full stop. For the purpose of facilitating the sale as it is statutory mandate under legislation 1908 as a means to obtain a certificate from the jurisdictional deputy commissioner. So facilitate for the purpose to facilitate execution of the sale deed. For the southern rock applied for No objection certificate. On 19/9/2024. Online. In the designated portal. Comma. Seva settle. For the notified public service. Quote unquote. Unquote. Self-transfer. Post. Said application was processed by the designated public servant. Because the circle officer, Gram Revenue Circle, Bongaigaon, Assam. By an order dated 17. State application on the ground the petitioner did not submit up to date revenue and see with the subsequent to rejection of the application on 17/11/2024. Petitioner again submitted an application on 29/8/2025 seeking extension of the notified public service, quote unquote, composite land sale transfer by meeting the deficiencies. Yeah, this time you have proposed it. Meeting the deficiencies recorded in the previous rejection order dated 17/11/2024. Post. Receipt of the said application was acknowledged by the reference comma, C stroke, 30 stroke, 50502 stroke 2025. Post. When the submission of 29/8/2025 service was not the petitioner within the stipulated delivery date, comma, the petitioner tracked the status of the application and the designated portal Seva settle and found out that the respondent number 4 had sent back the application to the land record assistant for a press report on 5/1/2026. Agreed by non-delivery of the notified public service component transfer stipulated application seeking a relief. Benefiting the position filed by the respondent of court on 12/6/2026. Dilating on the processing of the application of the petition dated 29/8/2021. Of the petition. Posted. In the affidavit. The respondent of court has stated that after receipt of the application, no update was available. Aspect of the subject was examined. And according view, the matter was reported from his end to the additional deputy commissioner. Bongaigaon. By an office letter dated 13/10. The respondent of court has stated that at the time of presently, the application for issuance of no objection certificate in favor of the petition is pending. At the level of the land record system. It is pending. Mr. Das, counsel for the petition, appearing for the petitioner, has submitted that since the service composite self transparent. Section 21 of the Registration Act 1900 as amended. It is incumbent on the part of the respondent authorities either to allow the application for the no objections under for sale or to dispose of the application by way of a region order within the stipulated delivery period. Post op. It is not open for the respondent authorities to keep the application pending without disposal. Post op. He has submitted that the petitioner has in the application dated 29/8/2025 has met all the deficiencies according in the order of direction dated 17/11/2024, whereby the previous application dated 19/9/2024 was rejected. Full stop. He has pointed out that as per the Jamabandi within bracket records of right, comma, the class of the subject of is residential dash capital Roman 3. Within bracket. 1. Contrary to, contrary to the claim made by the respondent number 4 that the land, a class of land is quote unquote wetland. In his report dated 13/10/2025. In response, Mr. Goswami has referred to the report dated 13/10/2024 to submit that the regions are assigned therein as regards non-disposal of the application submitted by the petitioner for non-business submitted or sale. The contents from the contents of the reports submitted by the respondent number 4 on 13/10/2025. The additional state commissioner R. Bongaigaon. It is noticed that the land record concerned land record assistant submitted a field report on 13/10/2025. The respondent of 4 stating that the subject was under occupation of the petitioner and the same was then seen as quote unquote wetland. The respondent number 4 in its report dated 13/10/2025 had also reported that when also reported that the zonal value rate for us to record to issue no objections or anything for a subject line could not be found. Yes, Mr. Das, anything to be noted?
No, my lord, these are on what basis they have found this.
No, they have to either
Otherwise, it
allow,
was residential
they
class
have
three
to
land.
bring to its finality.
Yes, class 3 land already there.
That I have recorded.
Yes, it's already there.
Mr. Das has further submitted that the intended transfer is not inter-religious transfer, and therefore standard operating procedure notified by notified by the Revenue and Disaster Management Department, Government of Assam, by notification dated 9/9/2025. Station. Read registration within bracket Assam amendment. Section 21A. And again by the registration within bracket Assam Amendment Act, 2021. Session reaches under. Eligibility criteria. Notification dated 11/11/2022, comma, anyone in whose name figures in Jamabandi stroke record of rights or his stroke her stroke successor or his stroke her registered power of attorney holder is eligible to avail the service, comma, quote unquote. Composite land cell transfer. The notification dated 11/11/2022 as mentioned. The Deputy Commissioner has mentioned a designated public servant, comma, quote, Deputy Commissioner stroke to be nominated by Deputy Commissioner, unquote. Full stop. The documents required so outlined. From the court, from the Jamavan. Condition is annexer 1. Transfers. That the name of the petitioner is duly reflected clearly in respect of the subject of the petitioners has asserted that the application dated 29/8/2025 was submitted along with all the requisite documents. The report submitted by the respondent of 4 to the additional Deputy Commissioner R. Omega is a report recording his views. It appears to be a report recording recording his views, interim in nature. Appears to be a report, interim in nature, appears to be a report, interim in nature, recording his views on the application seeking the notified public service composite land sale transfer for consideration of the additional District Commissioner R. Bonagam. From the report dated 13/10/2025, it clearly emerges that the application dated 29/8/2000 application received by the acknowledgement number NOC/13/50502/2025 dated 29/8/2025 has not reached any finality. While acknowledging the fact that the subject was under possession of the petitioner, it was reported that the subject land was then seen as quote unquote wetland. Full stop. Whether the subject of, which is of Residential. There's Roman 3 class. Cannot be transferred by way of sale. Merely because it was mentioned as, it was seen as a wetland. It was then seen as a wetland by the concerned land record assistant. From an issue which is yet to be examined by the competent authority. First, this court is also of the considered view that merely because zonal value rate was not found for the subject land, an application seeking no objection certificate for transfer of the subject land by way of sale is to be can be kept pending as the right of the petitioner, as such right of the petitioner is relatable to Article 300A of the Constitution of the Union. As the respondent operates have not brought of the application with the 29/8/2025 to a finality till date. Despite lapse of more than 11 months, more than 10 months since 29/8/2025, obvious petition is disposed of, directing the respondent authorities, more particularly, the respondent number. Respondent number? More particularly. Yes, the respondent number. District Commissioner. District Commissioner. Yeah. Respondent number 3.
Yes.
Bracket or Victor. To bring the entire process to finality in strict compliance of the statutory mandate contained in Section 21 of the Registration Act, as amended, by adhering to the procedures outlined in a notification dated 11/11/2022. Within a period of 30 days from today. So if in the processing of the application from today, within a period of 30 days from the date of submission of a copy of this order at his office by the petitioner. If in the processing of the application, any further document is necessary from the petitioner, then the respondent number 3 shall inform the petitioner in writing as regards the deficiency, if any, date of 15 days from the date of submission of the copy at his office. In such situation, the time period of 30 days is to be calculated from the date of meeting the deficiencies by the petition. So, will not mention about region order. And he will pass a region order dismissing order. Citing some pretext, which may not be tenable. Then again it will prolong.
Yes, but again it will come.
Taragote likho. Having regard to the contents of the notification. Dated 2025. It primarily appears that the procedure laid down in the notification is not applicable in the case law.
Item 14.
Yes, instead you were submitting something.
Yes, your lordship.
You have the bank transfer. How much is the amount?
Your lordship, it is 0.44 paisa.
0.44
Yes. And one
Paisa?
Yes.
or rupees?
Paisa, your lordship.
Paisa.
And another transaction is of 32 rupees. That is the disputed.
32 rupees.
Yes. Total transaction is 1750 rupees and 150.
Total
Two transactions were there identified. That is 1750 and 150.
750 and
1750 and 150.
150. Total?
That is 1900.
We keep this 1900.
Yes, sir.
Lien is 1900.
Yes.
Hard. Mr. N.K. Allo. Counsel for the petitioner. Second, what is not the Okay, have you received any instruction?
Yes, we have received.
To that extent,
Yes.
1900.
And re-KYC. Yes, sorry. And re-KYC.
Huh?
That is KYC. He has to complete his KYC also.
Mr. M. Sharma learned. Also for the respondent of the not available. But in this petition is stated under Article 226 of the Constitution of India. The petitioner has assailed an action on the part of the respondent Bandhan Bank. Savings bank or what? Savings account. Savings bank account.
Yes.
What is your number? Okay, number.
It is para 6.
Oh, para 6. 202000049365 In debit twist condition. It is stated that the petitioner opening the said savings bank account. As on 9/5/2026, the account, bank account, rupees 43,360 within the account. The petitioner stated that he did video. Meeting bank account. we came to learn that the bank account had been placed under his instruction, and therefore he was unable to withdraw or transfer any amount from the same bank account. When the petitioner, respondent number 2, authorities in the respondent number 2, he was informed that the bank account had been kept in debit freeze condition on receipt of communication from cybercrime authorities regarding complaints registered in the National Cybercrime Reporting Portal, but no document was furnished to him regarding such communication. The petitioner has contended that if any communication is received from the as regards Commission of Cyber Crimes from the National Cybercrime Reporting Portal NCC as regards any definite amount as suspicious transaction stroke credit, then the respondent number 2 is not authorized. This debit freeze instruction over the entire amount of the instruction over and above the instructed amount. Whereas it was issued to the responding authorities, including the responding of the 1856. Post of para. Mr. Sharma, learned counsel appearing for the respondent number 2, has submitted that instructions to the effect that the debit freeze instruction see from NCCRB.
Maharashtra and NCC are Odisha.
Debit freeze instruction was received from the CCRB that complaints were registered. Complaints regarding suspicious transaction stroke credit were received from
Thane City Police Station,
Thane
Maharashtra,
City Police Station, Maharashtra,
Vishnu Nagar.
Vishnu Nagar. Only one.
And second one is also.
And
this is UPD Bhubaneswar.
write down.
Yes.
Write down in a piece of paper.
Yes, sir.
UPD Police Station.
UPD
Police Station.
Police Station.
Uttar Pradesh.
Bhubaneswar, Odisha.
Bhubaneswar, Odisha. Mr. Sharma has fairly submitted that complaints are regarding suspicious transactions stroke credit amounting to rupees 1,750
Yes.
and rupees 150 respectively. Right?
Yes.
Post of. He has submitted that since there are already 2 suspicious transactions stroke credit in the bank account of the petitioner, comma, there is possibility to safeguard your interest.
Yes, Your Lord.
There is possibility of receiving further complaints regarding suspicious transaction stroke credit in relation to the bank account of the petitioner. Well, having had and consider the submissions of the learned counsel for the parties, comma, this court is of a considered view that the action of the respondent bank in keeping the risk is not sustainable to the extent that it exceeds the scope of direction received from the investigating authorities, that is, Eduta, Odisha, Bhubaneswar, to the NCCRP. So the power exercised by the respondent bank is not an independent power. The bank, apart from implementing the directions made by the investigating authorities, also acts as the custodian of the bank accounts, though it is submitted by the learned counsel for the respondent bank that in view of two suspicious transactions stroke credit, there is possibility of more complaints as regards suspicious transactions stroke credit at a later point of time, such submission, in the considered view of this court, advanced on behalf of the respondent bank is not acceptable at this stage. The apprehension expressed on behalf of the respondent bank regarding receipt of instruction in future cannot be a basis for keeping the entire amount in the concerned bank account of the petitioner on hold over and above rupees 1900. This court.
KYC.
Mr. Sharma has further submitted that so when the customer does not submit KYC form in time, and in the case in hand, the petitioner till date has not submitted the KYC form with the particulars KYC form. So it will have to open it. Bank account in respect of the balance amount lying credited thereof, subject to submission of the KYC form and any other or further instruction made by any competent authority in accordance with it. Disorder disposability.
Daily list, item number 3.
The repetition stands allowed to the extent indicated. Yes, Mr. Khan. Yes.
Let him complete or?
This is case interim order.
Yes. My case is that.
Interim order.
Yes.
Yes, my lord, my fair submission is that order was passed before reducing any evidence. But at the same time, my lord, my election petition was annexed as annexure 2 by the petitioner without annexing the relevant document before this honorable.
Order is there.
Yes, my lord.
Order is self-sufficient.
And honorable apex court also held in 1975 SS4 SSC 480 in para 6, my lord, that court would be justified in ordering a recount of ballot paper. Election petition contents and adequate statement of all.
Shall we examine your election petition?
No, my lord.
Then that will be more fatal for you.
No, my lord. But
You have to make out a case
yes.
that election tribunal can dismiss it outrightly
Yes.
when no sufficient averments and grounds are made in the election petition, right?
Yes.
Second, if you read it properly,
Yes.
sometimes the other respondent, the elected respondent, can come directly challenging the election petition itself that no case is made out.
Yes.
Now read again. Para 6.
Para 6, my lord. Yes. The election petition contains an adequate statement of all the material facts on which the allegation of irregularities and illegalities in counting are found. And second, my lord, on the basis of evidence adduced, such allegations are prima facie established, affording a good ground for believing that there has been a mistake in counting.
So evidence.
Yes, my lord. I have already.
That is also in para 6 evidence.
Yes, my lord. But
Now here you have filed a petition saying that 1 or 2 vote
yes, only one.
irregularity,
Yes.
and has asked for an interim order. The tribunal has passed an interim order with the condition that is interesting.
Yes, my lord. Definitely.
That to facilitate this court for recounting of votes on or before the next day.
Yes. Yes.
That is, if he can say, if he directs that Deputy Commissioner, please preserve the ballot papers in sealed trunks, so that if the writ petition by the final order, recounting is ordered, the ballot papers are found in sealed condition, preserved.
Yes.
But he said, I'll count now before the next day. That is not permissible. Any evidence is laid?
No,
No.
my instruction is that issues not yet been cleared.
Right. As an interim order, that cannot be passed. Observe, while
Yeah,
parting
distributed
with, we
period.
will observe that Deputy Commissioner shall preserve
Yes.
the ballot papers in sealed trunks. That Deputy Commissioner shall ensure preservation of the ballot papers in sealed trunks till the final order is passed in election petition number so and so. Interim order is to be set aside. Why you are worried? The sale is made in this writ petition, preferred under Article 226 of the Constitution, to an order dated 6/3/2026, passed by the Panchayat Election Tribunal, Gwalpara, whereby the Panchayat Election Tribunal has directed to produce the ballot papers of the election. Unit member, it is called unit member nowadays. Ballot papers of the election to ward member of ward number 8, Lejam, Lejam, within bracket Kho, under of team number Sunari Gaon Panchayat. And number 2, Kamaikha Bari, Anchalik Panchayat, within the district of Gwalpara, Assam. The petitioner is a permanent resident of village Lejam and an elector from 8 number Lejam, bracket Kho, Gaon Panchayat. No, ward number 8. Ward number 8. So, Kera 2, what are you are saying? Sunari Gaon Panchayat, Lejam Gaon Panchayat. What is this? See your certificate. Where is your certificate? Okay, okay. Was an elector. Is an elector. From ward number 8, comma, Lejam, Lejam, perhaps. Z or J? You are translating yourself to J. ZAM. Putting together call. Under 13 number, Sunari CHUNARI. Some state election commission by a notification dated 2/4/2020 notified the dates of general election, notified the schedule of general election to the Panchayat in the state of Assam. So as per the notification, the general election to the Panchayat in Assam were to be held in 2 phases as per the schedule. Insofar as election for ward members under 13 number Sonali Gaon Panchayat, comma, the date of this is the one table. Yes. It was the election was to be held in the second phase. First of, as per the schedule mentioned in the notification, comma, the date of filing nomination was 11/4/2025. The date of publication from the list of validly nominated candidate was 12/4/2025. First of. Date of publication for a list of contesting candidates was mentioned as 17/4/2025 with the date of poll on 7/5/2025. First of. Para. After the notification dated 2/4/2025, comma, the petitioner, the respondent number 6 and 1 Shahjahan Ali Mondol submitted nomination papers. I don't know how many have filed. Their nominations are valid,
Yes.
basically. Remain in the fray. Sorry, After submission of nomination papers, nominations were submitted for election to election one from exam. After scrutiny of the nomination papers and on the date of publication of list of contesting candidates, the petitioner, respondent was 6, and one Shahjahan Ali Mondal remain in the fray. Full stop. The date of the polling was accordingly held on 7th 2025. Full stop. As per the date of counting mentioned in the schedule to the notification, the counting was held on 9/5/2025. The counting of ballot papers were held on 11/5/2025. So after counting, the petitioner was found to have secured 360 votes, number of votes, as against 358 number of votes secured by the respondent number 6. Full stop. Shahjahan Ali Mondal secured 60 number of votes. Full stop. After counting, the authorized officer issued notified the results in form, in prescribed form X Roman 17 within bracket A, as per rule 44. Declare the results. Declare them. As if prescribed form Roman 17 A, as per sub rule 7 of rule 44 of the Assam Panchayat within bracket Constitution bracket close rules 1995. Thereby declaring the petitioner as the winning candidate from ward number 8 Lejam Ho constituency under 13 number selection on 12/5/2025. Postal. Fair enough. Where is your agree by and dissatisfied with the manner of counting the ballot papers and the declaration of result. The respondent number 6 has deferred an election petition under section 127 of the Assam Panchayat Act, 1994 as amended, challenging the validity challenging the election of the petitioner as one member from the 13 number Sunmari Gaon Panchayat and 2 Pamaikhabari Anchalik Panchayat. 2 now. On receipt of the said election petition, same was registered as Miss within bracket election. Bracket close. Number 2 of 2020. In the election petition, the respondent number 6 has contended that as per report of the ballot paper account, form number Roman 8, declared by the presiding officer on 7/5/2025 for the Gaon Panchayat election, 2025. For ward number 8, Lejam, Kho, there were total 960 ballot papers, out of which 821 votes were polled. However, in form 19A, the final result sheet, the total votes polled were shown as 820. So thus, there was a difference of 1 vote in the final result sheet. As per the final, in the final result sheet, making it apparently clear that the counting was done in a lackadaisical manner. The respondent number 6, the spider, contended that there were rejection of 40 number of ballot papers cast in favor of the petitioner. Cast in her in lady or male?
Both,
No,
both
you're
lady.
wrong. Cast in her favor in arbitrary manner. It is further alleged that the counting officer had allowed some unauthorized person to enter into the counting hall, and those persons were involved in malpractices, acting in favor of the petitioner, who has been arraigned as respondent number 3 in the election petition, alleging corrupt practices in counting by the agents of the respondent number 3 in the election petition, that is the petitioner, and preparation of a false cert. So alleged in the election petition. First of para. After registration of Miss within bracket election case number 02/2025, notices were issued to the respondents arrayed therein, including the respond number 3, that is the petitioner hearing. On receipt of notice, the petitioner entered appearance represented by Land Council, Gustav, Pera. Plus, regarding the election petition that would affect that. The counting officials rejected 42 number of poll votes, out of which 40 number of votes were cast in favor of the election, petitioner were rejected. Whereas only 2 number of votes cast in favor of the respond number 3 were shown to be rejected. Stating so, it has been contended that had those rejected votes been adjudged as valid votes, then the results of the election would have been different. That is your case. As Dr. Lawrence, Standing Council, Panchayat and Rural Development Department. So there is number 1, 2. B Castro. AB Castro. Learned. Council on behalf of Mr. R. Dubey. And Standing Council, Assam State Election Commission for the response number 3. Mr. J. Living on some of the response number 45. It is a K colita. And it also for the response number 6. It is the election. The facts were count both secured by the contesting candidates for the election as one member from ward number 4 later. Party number were recorded. The prescribed form number Roman 17A. In terms of Rule 44. Sub-Rule 7 of Rule 44. Some constitution, some subject constitution rules Roman 19. Rule 44 of the Assam Panchayat the Constitution rules 1995 is provided for counting of votes and declaration for results of the election. It is the district commissioner or the officer as authorized by the district commissioner, is the case manager, has to declare the candidates who has received the highest number of votes in respect of every election to be elected to the particular office or seat, and publish a notice at his office, taking the name of the person so declared, and as the member of the Gaon Panchayat or member of the Panchayat or Jila Panchayat. Is required to forward a copy of the same to the State Election Commission for notification. First of, as per prescribed form Roman 17A, the petitioner secured 360 number of votes. 6 had secured 358 number of votes. It was for securing more votes than the respondent 6. The petition was declared elected. Was declared as the elected. Para. The stage when the impugn order dated 2000, it is not in dispute that the stage when the impugn order dated 2023 is passed. I'm sorry. It is not in dispute that the impugn order dated 2026 has been passed prior to the stage of evidence, recording evidence of any of the parties. On receipt of notice, all the respondents had submitted their written statements denying the allegations leveled by the petitioner in the election petition. The respondent number 1 and 2 had contended that the entire counting process was carried out following due procedure and there was no discrepancy on their part. From the part of the election petitioner, the election petitioner should have raised the same during the counting of votes. On the other hand, not recorded. In every order, it is not recorded. Huh? Recent statement you have submitted, that he has admitted.
Improved order, there is nothing here.
But it's 31, my lord.
But the operative part, no, it
Yes,
is respondent 1 and 2. You are 3.
But
3's contention is not recorded.
yes,
Okay. The operative parts of the impugn order are extracted. Taking note of the contentious released in the election petition and after taking note of only the contentions raised by the election petitioner in the election petition and of the respondent number 1 and 2 in their detailed statements, the impugn order has been passed. If we is silent about the contentions raised by the petitioner as a respondent number 3 in the election petition. Full stop. The operative parts, the relevant parts of the appeal order are in. The present patient is preferred. Raising a sole contention as the stage. But time for for it, no, vote. And once more. The order. Fiction tribunal. That not only directed to produce the ballot papers or the election of ward member. Ward Ejam Kho under 13 number Sunari Gaon Panchayat, but had also decided before the court under sealed plans, but had also decided for recounting of votes on or before the next date, 18/3/2026, which is impermissible. Is relevant to mention. It is operating in the case of relevance to mention that election petition filed under section 27 of the Assam Panchayat Act as amended. There is for the counting of the ballot papers of ward number 8, Lejam Kho. Set aside the election of the respondent number 3, declaring it as void. A case pleaded by the petitioner. Election petition in the election petition has already been admitted. Has already been admitted. So the prayer made in the election petition, the prayers made in the election petition are as above. Full stop. Para law regarding conditions. Law regarding passing order as to recount of votes is well settled. First of all. And the conditions to be satisfied prior thereto are well settled. Full stop. The provisions contained in some unsaid within the Constitution was common in the under the now in procedure of last of litigation. Para when the lawyer was settled from the appropriate so 2020 within bracket Ofsara Begum versus State of Assam and others, decided on 29/3/2022. First from the above aforementioned authorities, the law is well settled that an order for a recounting of votes can only be passed evidence are laid by the parties by election tribunal on the basis of evidence adduced reaches a satisfaction that the allegations are primarily established, affording a good ground for believing that there has been a mistake in counting or irregularity or illegal stuff. As the dated friends has been passed without recording of any evidence. That is, the stage of evidence and merely on the allegation made by the respondent number 3 as the election petitioner in the election petition. Is accordingly ordered. 60/2026 is therefore set aside and passed, making the interim order dated 11/6/2026 absolute. The rectification stands accordingly. This court, it is however verified that the district commissioner Gwalpara shall ensure preservation of the ballot papers for election held for ward number 8 Ajam Hall under Panchayat and number 2 Kamakhyabari Anchalik Panchayat under seal as per Hill so that if after Hill the final decision of the election commission on this election case number 0.
That period, my lord.
No, that is a independent authority. Why should I direct? You make an application before them. Election petitioner.
Yes.
That's tribunal.
Yes.
Item 15 for orders.
What happened? Notice out.
Service don't finish.
Mr. Abjad Muzumdar, learned counsel for the petition, and Mr. J. Henry, in your government. 1 to 4, as per 22/7/2026 of the Law Jima Court, the service of notice upon the respondent of 5 is complete. So, in view as the service of notice upon the respondent of 5 is complete, let the case be listed after 2 weeks in the appropriate, in the admission.
Lordship, can I pray for a date, Lordship?
No date.
Item 6 for hearing.
Hearing, sir. Control.
Yes, my lord.
Yes, so many councils possible. Not possible. So many councils, some other dates, long list in the cause list.
There are.
Talukdar, JMA Chaudhary, MH Loskar, and Mr. Qadir.
My lord, respondents are the elected members of the society, my lord. So all the members will be implicated as respondents, my lord, for good.
It is not possible, we will not keep it. Some other date. Not possible. Seat of paper for the members. Or it is properly recorded?
Yes.
Okay. Qadir, petitioner. SK Talukdar, standing counsel, corporation department. JMA Chaudhary, নম্বৰবোৰ আছে।
Yes,
MH Loskar. So, what is the issue? I can understand the issue in 2-3 minutes.
My lord, regarding my lord, the violation of the provision 26(3) of the Cooperative Societies Act, my lord, regarding my lord, the preparation of the electoral roll before conducting the election. And this honorable court earlier has referred the matter to the appellate tribunal and the appellate registrar, my lord. Registrar earlier conducted the hearing and had directed the concerned department, RCS, to conduct the election after preparing the valid electoral roll, because the earlier one had allegation that dead voters are there, and these are the allegations. But subsequently, my lord, the voter list was not corrected as required, and not as per section. Not it is the draft was not published as per. There is no chance of objecting the voter list was there. Accordingly, the election held, and the petitioners herein, though they have participated, my lord, in the election, and on the date of election, the anomalies are also there, and it is reflected on the marked sheet, my lord. In the marked sheet where the voters had appeared and cast their vote, and that was called for by the registrar, my lord. But unfortunately, the registrar, my lord, though it is apparent from the attendance register, there is manipulation, tampering, the eraser was used, all these, even that, my lord, it is held that it is validly conducted the election, my lord. So our petition.
So findings of fact.
Rejected.
Fortunately, my lord,
Findings of fact.
they have participated in the election, contested. After losing the election,
So that principal service jurisprudence that once participated with their eyes open,
Yes.
that is
they have
applicable or
accepted
not?
the electoral rule and
That
everything.
principle is applicable or not? That with their eyes open, they have participated in the examination, viva voce, and after finding them not selected, they cannot turn their back and say that this is bad. That what is that? Angur tenga. Right? That is their case. And findings of fact. If some, I have not opened the file, I have not brought the file also. But that is your case. According to Mr. J.M. Chaudhary, that you participated in the election.
Yes.
But suppose procedure was not followed,
Procedure.
but a voter's list was there.
Yeah.
On the date of submission of nomination paper, perhaps, right?
Yes.
So you could have very well examined and protested. Had you protested?
That period was past. The
Uh,
objecting period of the voter
You
list.
are, that is why, whether you are merely a member or a participant,
Participant.
then your responsibility is more.
Yes.
Had you been only a voter with no aspiration to become board of directors, then you could have said that, yes, I am not examine the voter list, but you are a participant.
One of them is the former chairman.
When election was held?
My lord, in 2024.
24. Only 2 years, 5 years, 10 years.
Well, before the next date, the record may be called for from the registrar.
No, first I'll have to derive satisfaction to record because it is a finding of fact.
Yes.
He has done it.
Yes.
We are in supervisory capacity now.
Yes.
More particularly when he is the supervisory capacity. So we are supervisory capacity over supervisory authority. So thing is more diluted now. Right? Mr. Taluda has understood.
Yes. In the department.
So supervisory authority over supervisory authority. So everything is diluted. Fact finding authority. So let us have it. September. List. So, it's September. Let them enjoy. Lost friends.
Yes, sir.